We are Legally Sis. Welcome to our podcast.
The information provided in the show is for general informational purposes only and should not be construed as legal advice on any subject matter. No attorney-client relationship is created between you and Duran Schultz Law.
Hi! Welcome to Legally Sis. I'm Attorney Wen.
And I'm Attorney March. Welcome to our podcast. After listening to our podcast, a number of viewers have approached me and asked me, what about the property relations of the husband and wife? So they'd like to know who owns what during the marriage, and in eventuality that they would separate, who owns what after they separate. So in this episode, we will be discussing property relations of a husband and wife and also prenuptial agreement.
All right. So Attorney March, since between the two of us, you are the one who's married, happily married, I think.
Yes, of course! No doubt about it. That's why I'm carrying the Schultz. It's Duran Schultz Law.
Alright. Okay. So for purposes of this podcast, let's discuss as to who owns what when you actually get married.
Correct. Before we proceed in discussing the property relations of the spouses, we have to draw the line as to the time frame, because in 1988 we have a law which is called the family law, which governs the property relations of a husband and wife. So any marriages that was solemnized before August 3, 1988, it would be the civil code that would govern. August 3, 1988 and onwards, the property relations will be governed under the family code.
Alright. Okay. So let's discuss first the property regime under the civil code. So when a party get married, what do you call the property regime by those spouses?
For marriages that transpired during the civil code or before August 3, 1988, the property relations of spouses would be governed in what you call conjugal partnership of gains. So it would include any fruits of interest of already existing properties prior to the marriage and any properties that they've gained after the marriage.
Okay. So how is it different from what you call, or other people will say, absolute community of property?
Absolute community property means anything that you owned before, during, will now be owned by the spouses. So if you have a condominium before the marriage, after the marriage, your spouse will now own it, assuming your marriage happened during the family code.
Okay, which is August 3, 1988.
Great.
Okay. Are there any other property regime that the spouses could enter into, aside from the absolute community of property and the conjugal partnership of gains?
Yes, of course. You can have actually any type of property regime that you'd want, so long as you've indicated it in your prenuptial agreement. But one of the most common would be what you call separation of properties, or absolute separation of properties, meaning anything you've earned or anything you have prior to the marriage and anything that you will be earning after the marriage will be completely separate from the ownership of your spouse.
So when does absolute separation of property takes place?
It must be emphasized that if you do not have any prenuptial agreement, the default in our family code would be the absolute community property regime. So if you do not have any prenuptial agreement, then you have no other option of the property relations between the two of you.
So you're saying that absolute separation of property must be entered into or agreed upon by the parties before they actually enter into a marriage.
Correct. That is essential because it is an exception to the rule of the absolute community property.
Okay. So I'm just curious, do you have a prenuptial
I knew it! You're going to
agreement?
ask me that question. Yes, I do.
Okay, so having a prenuptial agreement, what are the advantages of this one?
Okay, for parties that come from different set of lifestyle if you have, for example, a very rich husband and then a wife who comes from middle class, it would seem unfair for the family of the husband that everything that the husband owns before the marriage will now be owned by the wife. So, of course, one would just want to protect him or himself in case of separation. So, the solution to that would be to have a prenuptial agreement just to appease each other's party that you're not getting married because that person is super rich, or you're not a gold digger, right? You're just doing it because you really love the person.
Or, for example, that the other parties have been previously married.
Oh yes,
Yes.
you're correct. Yes, of course. Or that party would have children already prior to the marriage. That's also something. Or you are in a mixed marriage, uh, meaning your spouse is a foreigner. They might have different laws with you, so it would make sense to carve out who owns what in the prenuptial agreement.
Okay, that sounds fair. So after the parties have entered into, or let's say it's a default that the parties did not have any prenuptial agreement, and then they got married after the effectivity of the family code, which is August 3, 1988. What happens with their properties that have accumulated during the time that they are already married?
Well, they both are going to be co-owners of these properties. Even if you put, say, in the title XYZ married to ABC, it would still be co-owned by both of them, 50-50.
Okay. So I got this question last night. No, someone called me and asked, what happens if the wife got a gratuitous title, or that her father donated her a humongous or a huge chunk of amount of properties under her own name?
Yeah.
So who will own that property if that property is donated exclusively to that daughter?
Okay, that's a very good question. I would have to ask you a question to that. When was the donation, or when was the inheritance given? Was it before or after the marriage?
After the marriage.
Oh, that's a good answer, because if the other party would get donations or inheritance after the marriage, then that one would be solely owned by the other party. But if those properties were inherited or were donated prior to the marriage, then this would form part of the absolute community property of the spouses.
Assuming that they got married after the effectivity
Correct.
of the family.
This protects the assets of the family, what you call parental property, right? If you have properties from your mother's side or your father's side, and then they die, whatever they've given to you after you've gotten married, it will solely own by you. Your husband or the other party will not have any say on that property.
All right, so that's clear.
What if there is no prenuptial agreement, and then the parties would want to decide a different set of property relations? Because a while ago we've discussed the default is absolute community of property unless you have a prenuptial agreement. What happens now? You're already married. You don't have that option anymore. What's the recourse?
Okay, recourse is for the parties to have their properties judicially segregated or separated. So you have to go to the court and ask the court to segregate your properties.
So it doesn't necessarily mean that these parties are going to part ways as a husband and wife.
No, it doesn't necessarily mean.
Even bed and board, like legal separation.
Yeah, that's a different topic, but yeah, legal separation. One of the effects of legal separation, wherein the parties will be separated from bed of board, but they're still legally married, is that their properties will be divided between the two of them.
Correct. So that's good. People would have an option to have judicial separation of properties if they want. But of course, it's going to be more expensive
Of
had
course.
you just started with a prenuptial agreement in the first place.
Yes. So now that we have discussed property regimes of the parties during their marriage, what happens after if the parties will eventually decided to get divorced, annulled, or have their marriage declared or declared as null and void?
Okay, if there is a prenuptial agreement, you follow what's stated in the prenuptial agreement because the prenuptial agreement would state who owns what
Yes.
during and after the marriage. If there is none, then we go to the default, which is the absolute community property regime. So that would mean by default, the spouse would own 50-50 of whatever you've brought into and whatever has been earned during the marriage. In some instances, you can have some deviation to that when you have an annulment because you can ask the court of the distribution of the property when you are undergoing your annulment or petition for nullity.
So when you executed your prenuptial agreement, what are the things or the basic things that you will see in that agreement?
In a prenuptial agreement, you have to indicate the prospective parties, like prospective wife and prospective husband. And when you draft your prenuptial agreement, you should already have some form of idea who will own what during the marriage and even after the marriage should you part ways. Since this is a deviation of the absolute community property of regime in your marriage, you can opt to have conjugal partnership of gains, or you can have absolute separation of property or a mix. If you want it to be partnership of gains or conjugal property, that would mean anything that you've owned prior to the marriage will be solely owned by you. So you should be able to list down what these properties are right before your marriage. If you have a bank account prior to the marriage and how much is in there, if you have some lot or some condominium already existing, or if you have some investments already existing prior to the marriage and you want that segregated as community property, then you indicate that already so that it's carved out and separated from the properties of the spouses. You should also indicate what you want to do if those properties would be earning something. Because if you don't put anything, like for example, your condominium that you have invested in prior to the marriage is earning rent, who will be owning rent? Or if the property is already sold during the marriage and it has doubled its value prior to the when you bought it versus when you bought it and when you sold it now. So who owns the gains?
Okay. So is it even also advisable if you put in your prenuptial agreement as to who will spend, example, the what do you call this, the general expenses for the family?
Yes, of course, it makes sense. Particularly if the property regime among the spouses would be absolute separation of properties. So, in an absolute separation of properties, it really means whatever you've earned before and during the marriage will be solely owned by you. So, who will pay for the expenses at home? Because of the separation of property regime, then you should indicate who will pay for the children's schooling fees, who will pay for the household fees. That would include electricity, groceries. It can be messy if you don't put anything in there.
Yeah, it's also good to discuss between the parties as to who will shell out what expenses during their marriage.
Correct. You have to identify in a separation of property regime who or what are the legitimate expenses. Like travel is the legitimate expense that should be shared by the parties. And if they will be sharing it, is it going to be equal? Or would a driver be something that is considered as marital expense?
Okay. So now that the parties have executed prenuptial agreement, what's the process of having it enforceable? I mean, does after you executed the prenuptial agreement, does it just stop there?
Of course not. It has to be notarized, and it has to be recorded also with the local civil register where you're going to get married. Because if you look at your marriage certificate at the bottom, it would say if there is a prenuptial agreement or an agreement that would govern the property relations of the parties. If it's not recorded there, then it's like a scrap of paper, unless of course both parties would want to honor what's indicated in there. But if not, then all bets are off. The other party can contest. So a prenuptial agreement has to be executed prior to the marriage. That's why it's called pre or before nuptial. Nuptial meaning getting married. It has to also be registered with the local civil register where you intend to get married. And you have to make sure that that particular prenuptial agreement is recorded in your marriage certificate. So aside from those instances, what else do you think should be done after?
Okay, so if you have properties or real estate properties, make sure to have your prenuptial agreement registered with the registry of property or registry of deeds where your property is located as also. So it will protect you and your spouses with respect to whatever properties that you have in mind as indicated in your prenup agreement. Again, there's certain fees that the government agencies collect.
Right, of course. So going back to the contents of the prenuptial agreement, we've discussed who should be indicated there as the parties, what properties you should indicate there prior to the marriage, so you can know in specificity who owns what, and then you have to also indicate what happens as to the fruits, like the rent, earnings out of these properties that you've um, bought or invested in prior to the marriage. It also makes sense to indicate, as we've discussed a while ago, what you will be considering as legitimate expenses if you are going to have an absolute separation of property. You may want to also include what happens when you have marital issues, like if there is infidelity. Are you going to have some penalty?
Just like the celebrities in the United States. Yeah.
Yeah.
They have clauses when someone cheats, this wife or someone gets this one.
This amount of money, that's also possible. Because it's a contract that you will be freely entering into, you can indicate whatever you want so long as it's within the bounds of law.
Yes.
It's not immoral or against public policy.
Alright. So I think that's a good discussion about the prenuptial agreement.
Yes! If you have any other topics that you'd like us to discuss, please message us so we can consider. Bye!
Bye.